Well, good afternoon, everyone, and thank you for joining Simon Ellis and I on an overview of the proposed changes and some recent changes to the Australian consumer law. Before we begin, I'd like to acknowledge the traditional owners and custodians on the land on which we're gathered and pay our respects to their elders past, present and emerging. May I also extend our respect to all other First Nations peoples who may be within our audience this afternoon. You'll see in front of you a hub, and there's a number of windows. They can be manipulated in sizing, or they can be minimised by using the buttons that at the bottom of the screen. You'll also see that this session includes closed captioning. And if you've got any queries along the way or any issues arise during the session, you can submit those to us through the Q&A box, and our team can assist with you there. Now, in terms of an agenda, there's 7 points on this slide set that out. I won't read them out. I'll let you read them, and then we'll split those up between Simon and myself. So the first item which I'll cover is the changes to the definition of consumer. And this is a relatively recent change. It was made on the 1st of July 2021. You'll see in front of me I've got Miller's 2022 commentary or annotated commentary on competition and consumer law. And if you go looking in section 3, it still has a reference to $40,000 as the limit, although it does say unless otherwise prescribed. But if you're a practitioner and you've got a copy of this book, can I suggest that you go to section 3 of the ACL, cross out the $40,000 and write in $100,000, because from the 1st of July, the limit for consumer transactions increased from $40,000 to $100,000 for business transactions. And now there's some obvious exclusions to those which are normally well known. It excludes trading stock or consumables that are used to repair other goods. It excludes goods that are used in the manufacture that are used to transform goods into other consumables. It excludes goods that are not purchased. So it excludes goods that are purchased for resupply, etc. So whilst we talk about this limit applying to businesses, it's not every business transaction that it will apply to. But if it's a personal, domestic or consumer use transaction, then the purchasers will not have a limit at all, and that position is unchanged from the previous law. So the substantive change relates to business use and the limit from 40,000 to 100,000. So what does this mean? Well, I think what it means is that there's a range of protections that arise under the consumer law that apply to some business transactions which just were not there before. We've put some examples in this slide, and then we've taken consumer guarantees as a basis for this example. So consumer guarantees now apply to goods which are purchased up to $100,000. And if they're not of acceptable quality, if they don't correspond with their description, if they don't come with readily access to spare parts or repairs, then you may be in breach of those guarantees, and then you may have some penalties that apply for breach of the consumer guarantees. And the slide put up a couple of examples, at least. For example, industrial air conditioning you might purchase which costs less than $100,000, or some equipment or office equipment which was above $40,000 but is below the threshold of 100. The consumer guarantees now will protect those acquisitions, and it's something for business to be very much alive to. So what should one do? Well, certainly review standard supply contracts because of the scope coverage increase. Make sure that those contracts are ACL compliant. Compliance should also be assessed to avoid penalties. I mean, you need to be conscious that a wider range of transactions with a higher limit, with greater exposure, may apply, and so a greater level of sensitivity to compliance arises. Beyond that, the unfair contract terms regime for the time being remains unchanged, and misleading and deceptive conduct obligations and the laws that apply there remain unchanged. So the main issue which we want to identify there is the consumer transaction threshold increases and the impact of that for consumer guarantees.
Just sticking with the consumer guarantees, it's not only the limit, the monetary limit, that captures a broad definition of what a consumer is. There's also been a recent change to what is a major failure, and a lot of you may already know, but just to recap, it's a mandatory consumer guarantee in the ACL that whereas a good has a major failure, the consumer has a right to choose to reject the product, to demand a refund or replacement, or to have the good repaired. So the right to a remedy for a consumer depends on whether the failure is a major failure or not a major failure. Not a major failure is not defined under the ACL, but goods have major failures where they would not have been bought by a reasonable consumer knowing the nature of the defects, or they're substantially unfit for a common or specified purpose, or the goods depart from description or sample or are unsafe. That was the case, but since 18th of December 2020, the ACL has now explicitly made it the case that goods that suffer from multiple minor failures or not major failures may now amount to a major failure, and that will entitle the consumers to those rights to a refund or a replacement, or a repair if they chose. That may have been the case under the law anyway, but it's now been captured under the ACL. And the key question to ask is, would a consumer have chosen to purchase this product if they had known it had multiple minor defects, even if they were repairable? And one of the most illustrative cases of this occurred with the JCO, which relates to RVs or camper vans, I suppose. And the ACCC brought proceedings alleging that at least 4 of these RVs suffered from a major defect that entitled the consumers to a full refund, as opposed to having those defects repaired or under their warranty rights. And on the basis that JCO had said that they were not major failures and not entitled to those rights, the ACCC alleged that JCO had engaged in misleading and deceptive conduct, which is a common way that consumer guarantee cases are brought. So the court found that that there was a failure to comply with the statutory guarantee of acceptable quality, because the goods did suffer from a major defect, by reason of cumulative effect of minor defects, I suppose. And these were joinery that was substandard, there was poor workmanship, there was bed lifting apparatus which had failed, and a lot of those failures could have been and were fixed and could have been repaired, but it was the collective nature of all of those defects that the court found made that a major failure, that should have entitled the consumers to reject the goods and get a replacement or a full full refund. In terms of time, the repair works were undertaken, at least in one case, over 10 occasions over a 15-month period. And the court found that a reasonable consumer fully acquainted with those defects would not have acquired the RV, and therefore it was a major failure. JCO ended up having to pay a $75,000 fine because of the misleading conduct claim brought by the ACL, brought by the ACCC. In another case, the ACCC brought a claim that against LG, electrics manufacturer, in particular televisions, that they had engaged in misleading and deceptive conduct by representing that the consumers weren't entitled to a refund when televisions had gone beyond their warranty expiry period. In 2 cases, I think there was quite a number of cases brought by the ACCC, but with respect to 2 customers, the court did find that the representations by LG were were to the effect that the only rights that were available to the consumers were those under the warranty, and that they didn't effectively have rights under the ACL, and that is specifically a ground for misleading conduct under the ACL. But the interesting part about this case, and it's a difficult one to grapple with, is that part of the ACCC's claim was that LG had engaged in misleading conduct by not proactively advising customers about their ACL rights. And so the ACCC submitted that where a request for practical assistance not specifying a legal basis is answered with a response which focuses on a legal right, so that is a general request for assistance, and the response is only given in relation to warranty rights, then the ACCC said that LG engaged in misleading conduct. The court said that that was not the case, and it was primarily on the basis of the way that the court had characterised the nature of the communication between LG and the consumers, which was said to be in the nature of a negotiation as to what LG would do to resolve the situation, rather than a specific outlining of the rights available, legal rights available to the consumers in the circumstances. So these findings, at least in my view, are heavily reliant on the characterisation of that type of conduct and that type of negotiation. But it's interesting that in some ways you could say that there is no positive obligation on LG to inform the consumers about their ACL rights. The other interesting part about it was that the ACCC alleged that LG had engaged in misleading conduct by suggesting that the consumers were required to pay for the cost in determining whether the goods suffered from a major fault, and they failed in that case as well. And the court said unless and until a contravention is proved, that person must pay the cost of establishing the existence of a contravention. As I said, there were some statements by LG that to particular customers that were deemed to be misleading, and what separated them was because the court said they were unequivocal statements about what a customer would have to do, and what LG cannot do because of LG's manufacturer's warranties had expired. They had conveyed that the representation that no rights other than those rights available under the manufacturer's warranty were available. So they were more explicitly in the nature of these are the rights that are available to you and not available to you, as opposed to the characterisation of a negotiation about what LG was willing to do to remedy the problem with the televisions. Sorry, I will just mention one further thing. While there was no obligation to positively inform the customers of their ACL rights in respect of the call centre inquiries, it's important to note that Regulation 90 of the Competition and Consumer Regulations does require certain statements to be included in warranty information, and it is a breach not to include that.
So let's then move on to having a look at unconscionable conduct. And here we're referring to one case, we'll refer to maybe two or three, but this quantum housing case is one that arose in terms of what they call statutory unconscionability. So by way of background, under the ACL and also under the ASIC Act, there are two provisions that deal with unconscionable conduct specifically. The first relates to what's known as traditional unconscionable conduct, which you find in common law or equity, and it's where that conduct arises in trade or commerce or under the ASIC Act in relation to financial services. And then secondly, we have the statutory unconscionability provision in Section 21 of the ACL and the facsimile version of that in Section 12CB of the ASIC Act in relation to the supply and acquisition of goods or services, or in the relation to the supply and acquisition of financial services. Now, there's these two different limbs, and the purpose of this slide and the next is to identify same but different. and we'll get onto that in a minute. But before we do, one thing to note about statutory unconscionability is that it is not unconscionability generally. It only applies under Section 21 and Section 20 by itself as well, but only applies where there is an acquisition of goods or services, or supply of goods or services, or an acquisition or supply of financial services. So it's not a general unconscionable conduct limb per se. It's targeted to what the words say. So when we look into the cases, we see that things are evolving, and what's required is more than just a general concept of unfairness. And as the bottom bullet point on this slide notes, it's got to be far outside the normal commercial norms of acceptable conduct. And the case that's identified there is one of ASIC and Cobalt. And you may have been following this case. It's been sort of tracked through from first instance to the full court of the federal court and now to the High Court. But in that case, ASIC pleaded what I call a systems case. That, as I said, Mr. Cobalt's conduct was unconscionable in relation to a system that he had with his customers as a whole, as well as his conduct in relation to 4 particular customers who they identified. So at first instance, the judge found that there was unconscionable conduct. They said that he had his book up system, which is a credit system which allowed predominantly Anangu customers at his general store in Winterby in South Australia to buy goods on credit. They were charged quite a large amount of interest. They would then have their book or their credit paid for by deductions from monies that hit their bank account. Mr. Cobalt didn't actually know how much they had in their bank account. It would be a bit of a hit and miss in terms of his attempts to deduct the money. And there were people there who decided not to pay him, and they did a runner on him, and he didn't chase them. So there's an interesting factual background to this book up system. But the judge at first instance said, well, Mr. Cobalt, you're unconscionable because you gave this credit system. And although it gave some benefits, you took advantage of your customers' poverty and their lack of financial skills, and you tied them to dependency upon your store. Mr. Cobalt appealed that decision, and the full federal court found that although his customers were in fact vulnerable, his dealings with them did not amount to unconscionable conduct. His customers had a basic understanding of the book up system, and they voluntarily entered into these arrangements. And importantly for the full federal court, they found that he did not act dishonestly in any way. ASIC didn't like that decision. They appealed the decision to the High Court, and they argued the question of vulnerability. And they said that the full federal court had misconstrued the vulnerability issue, because they said the vulnerability of Mr. Cobalt's customers that led them to willingly enter into this book up system against their interests is what needed to be focused on, and the full federal court had wrongly treated these factors as excusing what should otherwise be regarded as unconscionable conduct. In a close judgment, 4-3, the High Court dismissed ASIC's appeal for the judge's finding that it was not unconscionable conduct, and 3 dissenting. I think crucial to the High Court's decision, or at least the majority decision, was a finding that Mr. Cobalt did not obtain any unconscientious advantage from his conduct. And I'll just draw 2 quotes from the judgment to your attention. The first was by Chief Justice Kiefel, where Her Honour noted, the difficulty with ASIC's system case of statutory unconscionability lies in identifying any advantage that Mr. Cobalt obtained from the supply of the book-up credit that can be fairly said to be against conscience. And in her slipstream, Justice Keane has noted that ASIC did not establish that Mr. Cobalt exploited his customers' socio-economic vulnerability in order to extract financial advantage from them. So there we have that. It sort of reminds me also of another case from probably almost a decade ago of the ACCC against CG Bovardis Holdings. And in that case, there was a lessee. They were wanting to sell their business. they needed to renew their lease, but they didn't have a right of renewal. They had no option. And in order to gain an option and extend their lease to be able to provide the premises to a buyer of their business, they negotiated with the lessor, and the lessor said, well, I'll give you it, but you have to release me. You have to abandon all the claims that you may have against me as lessor. And the lessee thought that was something that they shouldn't be able to ask for. Now, in hindsight, I think it turns out that the value of any claims that they may have had was probably only worth about $3,000, but that wasn't known at the time, and the lessee certainly thought they were worth a lot more. But when it went up to court, and this went all the way to the High Court basically said inequality of bargaining power is not the same as equitable disadvantage per se. And in any event, when we're talking about a disadvantage, it's not enough to have a disadvantage. The person, at least under common law and traditional unconscionability, has to be under a special disadvantage. And more to the point, driving a hard bargain does not amount to unconscionable conduct. It's not on its own. And here the lessee had placed themselves in a position where they had no option to extend the lease. That was a position that they had entered into through a contractual relationship. The fact that that gave them a position of weakness in a negotiation wasn't a factor that you could blame the lessor for. The lessor wasn't acting unconscionably in terms of their rights. So it was just a hard bargain, and too bad, how sad. It's not unconscionable. Then on to the quantum case. In this case, we have a manager of a property investment scheme, and they threatened fees and pressured and misled investors so that they could get their preferred managing agent appointed. And the court decided this, in fact, was unconscionable conduct under Section 21, so statutory unconscionable conduct, even though there was no special disadvantage or vulnerability identified. So this stands in contrast to the traditional or equitable common law unconscionable conduct. And the slide here has a few examples of quotes dealing with how unconscionable conduct is defined. So conduct that's so far outside societal norms to warrant condemnation as being offensive to conscience, or commercial bullying or pressure and sharp practice, using the superior bargaining position to act in an untoward manner, behaving contrary to an industry code, or systematically misusing a superior bargaining position by dishonestly misleading counterparties. So you'll see it's more than just using a position. It's using it in a particular manner to a particular level, which is contrary to a standard which society holds as being conscionable. This is important to note that this is in contrast to, as I say, the traditional unconscionable conduct rule, because we're dealing here with statutory unconscionable conduct. So this slide tries to wrap some of this together. So we have on the left-hand side, as I'm looking at it, hopefully you too, we have the unwritten law, the Section 20 provision in the ACL and the corresponding in the ASIC Act. And then the right-hand side is the statutory unconscionability, which we posit is broader because it doesn't contain a necessity that the person who is the called victim of unconscionable conduct is suffering from a special disadvantage. So that's one thing to be take care of. Relatively recent example perhaps of this is a case from 2021 involving the ACCC and Telstra, where Telstra faced $50 million in penalties for engaging in unconscionable conduct in contravention of the statutory unconscionability provision. What they were doing was selling postpaid mobile phones. There's being sold to 108 Indigenous consumers at licensed Telstra stores in Broome, Casuarina, Palmerston, Alice Springs and Arndale, and this occurred over a period of about 2.5 years. Telstra received the penalty after admitting to the contraventions, and here's a short sort of shopping list, I guess, of some of the contraventions that they admitted to. The first was that they entered into they got the consumer to enter into more than one contract for products and services on a single day. They engaged in conduct that was involved unfair tactics by not giving full and proper explanation of the matters relevant to the contract, such as the nature of the base costs, the total minimum monthly liability, and the risk of potentially unlimited excess data charges. They falsely represented or created the false and misleading impression that the consumers would receive a device or devices free of charge. And we know that the concept of getting something for free is a matter that the regulators pay particular close scrutiny to. They admitted not taking adequate steps to determine whether the cost of the products and the services were in fact affordable for their particular consumers. And perhaps more egregiously, they were found and admitted to manipulating credit assessment and the forms and falsely representing to the consumers that they in fact passed the credit assessment when they would not have otherwise have been approved for them at all. And then another issue was that they admitted that they had exploited the consumer's lack of understanding of the terms that applied to the transaction, and also took advantage of a cultural propensity for Indigenous Australians to express agreement as a means of avoiding conflict. So those factors came into play in the setting of the penalty, but also relevant to the penalty were the following matters. Telstra set up a system which incentivised targets for their licensed stores based on the number of sales of post-paid services, and rewards were increased depending on the volume of post-paid services that were sold. And that systemic incentivisation then went down the chain, and it led to the Telstra licensees employing techniques to meet those incentives. And senior Telstra executives were aware of this. And they were also aware, and they admitted that they were aware, that the system had the potential to encourage improper sales processes. On top of that, they found not to have implemented effective systems or training to prevent improper sales practices or properly respond to complaints. And they failed to act despite growing management awareness of improper sales practices and reports from Telstra's credit risk department. In fact, Telstra sold affected customers' debts to third-party debt collectors, and despite this growing awareness of what was happening, they failed to change the debt selling policy or buy back the debt at all. So not implementing effective systems or training, and not acting with knowledge that was obtained were matters that were relevant to the imposition of the penalty. So let's just go then through these case studies. There's 3 here, and we then also have Telstra, which we mentioned before. I might add one more, but we had Cobalt, which we've talked about already, which was no unconscionable conduct, even though people were charged high interest rates, and the court found he didn't keep good records and so forth, and people were having to pay for goods at a much higher rate than they would otherwise have to pay if they had the monies available then. Medibank was also no unconscionable conduct. That's where consumers were not told about changes to the scope of health cover, which limited pathology and radiology benefits, and obviously meant that people thought that they might have cover when they didn't, and they're going to incur more out-of-pocket expenses for the insurance dollar that they paid. And then the third example there involves Coles, and you may recall where Coles was getting suppliers to help defray the cost of their active retail collaboration program and pay for shop space and so forth and advertising. And the court found that Coles suggested that if suppliers didn't pay, then Coles would reconsider, quote inverted quote, their supply agreements, and that was found to be a threat, which was both a serious and a deliberate threat, which would undermine the relationship between the parties, found to be unconscionable, and it gave rise to a $10 million penalty. 6 weeks ago, there's also probably the most recent instalment in unconscionable conduct cases, worth noting from the High Court, and that's one of Stubings and Jams number 2 Pty Ltd. This is a case where a gentleman, Mr. Stubings, had 2 properties in Narre Warren. He wanted to purchase a 3rd property in Fingal. Problem for Mr. Stubings was that he was unemployed. He had no regular income. Lord knows how he was really satisfying all the debt that he had, but he wanted to increase his debt by $900,000 to get this other property in Fingal. He did have a company. It's called Victorian Boat Clinic Pty Ltd, and when he saw a financier and the financier's agent, they said, okay, what we can do is we can do an asset-based loan with you. And you provide a personal guarantee. The loan will be secured by mortgages against your 2 properties and also against this Fingal property as well. And we'll do it through your company. Now, putting it through his company meant that it bypassed the National Credit Code requirements because it was not for personal credit, it was for business purposes, which it was not. So just keep that in mind. He was then told to see an independent lawyer and an accountant. And he came back and he gave signed certificates saying that he'd received independent legal advice and independent financial advice. And there's a question mark whether he did get truly independent advice. But no surprises, shortly after financial close, the company defaulted on the loans, and 2 of the properties were sold to pay for the default. This got taken up to the High Court, and the High Court, looking at the questions of whether or not Mr. Stubings was under a special disadvantage or not, found that he was. They said he'd entered into an improvident transaction. And this improvident transaction involved an unemployed man with no income who used his only other properties to secure this Fingal property, and that alone demonstrated his inability to make a realistic assessment of the consequences of the transaction, and that showed his vulnerability. As a factual matter, the trial judge had this description of Mr. Stubings. He said he was unsophisticated, naive, and with little financial nous, completely lost, totally unsophisticated, incompetent, and vulnerable. So certainly a very clear impression of this gentleman was reached by the trial judge. And while there was no finding of actual knowledge by the agent for the financier, the court did find that the agent had a lively appreciation of the likelihood that the loss of Mr. Stubings' equity in his Narre Warren properties would be due to his financial naivety and the absence of his income. And that was sufficient to establish unconscionability. So what we have here is it's a warning to financiers. I guess it says that you can't just rely on certificates on their face. If you are on notice that somebody may have an incapacity to pay, it's no good just getting somebody to say, I've explained the contract to them and they understand the contract. You can't be willfully blind. And importantly here, I think the High Court found that on its face, while the certificates confirmed that Mr. Stubings did understand the effect of the finance contracts, the certificates did not themselves contain anything which inferred that he had turned his attention to how he could in fact service the loan, which is important.
So, as Ian has just described, there's some uncertainty in the law of unconscionability, and the regulators have suffered a number of losses in bringing cases of unconscionable conduct. And that sort of forms the backdrop to the ACCC pushing for a unfair trading practices prohibition more generally. And that sits at a level that doesn't have such a high bar to meet that unconscionable still does. So the ACCC has argued that there is a gap between the conduct that's not quite unconscionable, but still considered unfair by the courts. They've also gone on to argue that it is set to align with Australia with other jurisdictions that have unfair trading practices type prohibitions, although an analysis has been looked at that suggests that a lot of the overseas cases where they've been brought for unfair trading practices could be adequately dealt with by the ACL and in its current form anyway. The ACCC has also argued that various codes of conduct designed to protect small businesses, and in particular with major grocery chains, have failed to address these concerns. And also it may assist in addressing how digital platforms such as Facebook and Google and all those other sort of online digital platforms, how they treat consumer data, which is another large area of the ACCC's concerns. Rod Timms last year said that in a fairly broad quote, there are so many examples of behaviour that aren't caught by the law where 99% of Australians think that they should be in support of this kind of unfair trading practices. And it seems to be the case that the ACCC doesn't want a specific definition of what an unfair practice is. And the current proposal suggests that it would be establishing a generalised norm of behaviour, kind of in the same way that unconscionable conduct has had to develop over years through the courts. So the types of conduct that we're looking at with unfair practices is things such as failures to disclose key changes to products and services, the disclosure and sharing of personal data, which is in particular to digital platforms, where the consumer data is gathered, if it's unfair, and conduct that exploits the existing relationship with the consumer, but not to the standard of an unconscionable conduct. There's some problems with unfair trading law, and we have to say we don't quite know what it looks like at this stage. But a generic law prohibiting unfair practices, as I said, is going to have to evolve through the courts, and that is going to mean a period of time where the obligations of a supplier are fairly uncertain. That's likely to lead to costly litigation, and also we suspect that an unfair trading practices provision would outline certain practices that is considered to be unfair, but it would be a non-exhaustive list, and so it wouldn't resolve that uncertainty completely. Businesses may become too cautious because of this uncertainty, and make disclosures that are just too long and undigestible for consumers, and it's like a product disclosure document in financial services. And finally, there's private litigation, which could abuse the law, leading to long delays, long and evidentiary requires, favouring those with deep pockets.
So we've moved from unconscionability then, and we started to talk about unfairness, and this leads us then into the next topic here, unfair contract terms. And the relevant section here, I think, section 27 of the ACL, and it's a provision that really only applies to a standard form contract. If you're going to complain about an unfair contract term, the ACL can be a useful tool to have the term declared unfair if that term is found in a standard form contract. And the question is, have you got a standard form contract? Now, the law says if a party in a proceeding over a complaint about this alleges that the contract is a standard form contract, the law presumes it to be a standard form contract unless the other party to the proceeding establishes otherwise. So it has this reverse onus of proof that arises where that allegation is made. So that then requires the court to be able to determine, well, is this a standard form contract or is it not? And Section 27 lets the court consider matters that it thinks are relevant to determine the answer to that question, but it also prescribes a list of factors that the court must consider when determining or addressing this particular issue. And some of them are on this slide, but I'll read a bunch of them. So the first is whether one of the parties has all or most of the bargaining power relating to the transaction. The second is whether the contract was prepared by one party before any discussion relating to the transaction occurred with the other party. The third is whether any party was in effect required to accept or reject the terms of the contract in the form that they were presented. So take it or leave it type of approach. Fourth is whether another party was given an effective opportunity to negotiate the terms of the contract. And very often that's a hallmark of standard form contracts. Here it is, there's no negotiation. These are our terms, so if you want our services, that's it. And then fifthly, whether the terms of the contract take into account the specific characteristics of the other party to the particular transaction, which is in the last box on this slide, the question of whether the contract's being tailored to the transaction and to the type of parties that are taking part in the contract. And then there's a sweeper provision that deals with any other matter prescribed by the regulations. So these provisions apply to small business and consumer contracts. And we talked before about consumer contracts and the threshold increase to $100,000. And then we've got small business contracts here. Well, who's a small business? The answer is if you've got less than 20 employees, and we're excluding here people who are truly casual, but if you've got less than 20 real employees, and you're dealing with a contract that's got an upfront price of less than $300,000, or if it's a contract that extends over 12 months or more, then it's got an upfront price of less than $100,000, then that will be a small business contract. Point to note in the exclamation mark there is if you have no upfront price stated and you've got a regular supply contract, then you're running a risk of this being found to be a small business supply. Some examples then of instances where the court has found in cases that unfair terms have arisen. So the Matolo case is a supply issue and pricing. So exclusive supply, but Matolo was the party who determined the price that would be paid for the supply, and that determination occurred on delivery. So growers had no ability to seek better pricing or other buyers. To mention the wine grape growers case, where the growers would not be paid until 7 months after they'd delivered the grapes. JJ Richards is a well-known case involving automatic renewals, and then the only way to get out of the contract and terminate it was to pay fees to get it out. And then car rentals, maybe you've had a car rental claim like this yourself and experienced it, where the car rental agreement says, well, even if you're not at fault, you have to pay all the damage to the vehicle, which seems like and is a manifestly unfair term. It's not necessary to protect the interests of the hirer. Somebody else is at fault. And the last example there from Fuji Xerox, where I brought along the concise statement of claim, and there's 31 unfair terms that were alleged in this document. And the way that the ACCC sort of set that out is said, for example, there's 2 unilateral variation terms. The first allows a unilateral variation of prices paid by the customers. The second allows company to unilaterally vary terms without notice, which alters existing or creates new rights and obligations between the parties in favour of the varying party. And then it sets out why they're unfair, because there's no corresponding or counterbalancing rights on the other party to reject or negotiate a variation or to terminate the contract without penalty if the variation is not acceptable. There's automatic renewal terms, and in this case here, you couldn't cancel the contract unless you renewed or decided not to renew within a certain number of days before the contract ended. And this was a contract that went over a number of years, and the view was taken that you might miss the opportunity and become locked into a further term. And it was unfair because there was no requirement to give notice that the rollover deadline was approaching and there was a real imbalance between the parties, and so forth. So it's worth having a look at these types of cases, looking at liability limitation terms, for example, where here you had to indemnify the other party, even in situations where your agent or contractor had caused or contributed to the loss or damage in a manner which went beyond what was commercially necessary, and without you then having corresponding rights or protections as the customer in the contract. So it's one-way traffic, and it's over the top is the short head note from that type of requirement, and it goes on and on. Unfair payment terms, non-reciprocal obligations, and so forth. So there are a number of cases that are worth looking at. Take-home message is, if you have a consumer contract or you have a small business contract, so that is, you are dealing with somebody who's got less than 20 employees, and then the upfront price is less than 300 or over a term less than $1 million. You need to pay close attention to your contractual terms, because they can be declared to be unfair and they can be removed, and then there's cost consequences of having litigation over that. And then we say, but wait, there's more, and this is one of the proposed changes. So there's 4 changes here which I'll identify from draft exposure legislation that got put up in August last year. So obviously we're in the election at the moment, it's all on hold, and we'll see whether this continues post-election. But one of the significant changes is to say, well, if there's an unfair contract term, not only can the court declare the term void, but we'll put some teeth into this and give the court power to impose a civil penalty for that conduct. I think that will, make business certainly sit up a lot more and pay much closer attention to these terms. At the moment, it's sort of name and shame, but if there's financial penalties involved as well, that will bite. The second is to remove the price caps about the application of the unfair contract terms to standard form contracts. So to say it will apply to any standard form contract, regardless of the amount of money involved in the contract. So if you've got a take it or leave it, here it is, no negotiation terms, the proposition is that these unfair contract terms apply to that, and there's no cap, no thresholds. And then the proposition that the court will apply presumptions that certain contract terms are unfair if there have been findings in earlier cases of the same sorts of terms. And then the last proposal here is to change the small business threshold from 30 employees to having less than 100 employees. So, well more than doubling, nearly tripling, more than tripling the employee threshold, and changing it to having alternatively an annual turnover of less than $10 million. So I'll just talk about the presumption then of unfair contract terms on the next slide. So the proposal is, where you've got a contractual term and it's been declared unfair previously by the court, if you've got another term and another contract that has the same or substantially similar effect, the proposal is that be deemed or presumed to be unfair if, in 2 instances, firstly, if the same counterparty is using that type of clause, fair enough. Secondly, where the term's used in the same industry by a different party. And that's where you really sort of ask yourself whether the presumption's fair. Because one might anticipate that a clause could be substantially the same, but it might be in a very different context. I think the drafters of this presumption have beneficial thinking, that is saying, well, if the court's decided that it's unfair to be unable to vary terms or have things imposed upon you without the ability to get out without penalty, well, that should be unfair generally, but why then limit it to the same industry? Why not then say it just applies full stop? So if you're going to say, well, an industry suffers from the same sort of unfair terms, and then everybody in the industry should be on notice of that, the fact is that they're not. Whilst ignorance of the law is not an excuse for breaching the law, you can see circumstances where if a presumption is to apply in the same industry because there's been some decision in the same industry about somebody else's contract having a similar term to yours, you may well not know about that at all and not have the opportunity to alter your terms. So that's worth knowing about. As I say, it's a presumption that is proposed. It's not yet law. Whether it'll go forward in what form remains to be seen. So lastly, a checklist here of a number of things that you can do to refute whether or not your terms are unfair. These are questions to ask yourself as you're assessing your own contract terms. I'm sure you'll be able to read those for yourselves, but we'll just skate over them quickly. So first one, can you objectively justify the term as reasonable in order to protect your business? Is there some risk that you can identify that is a realistic risk that you face that needs protecting by a contractual term? Or are you just trying to steal a march and get something more than you're reasonably entitled to? The second is, can you target the clause better? Do you have to have the broad consequences that you seek to impose upon the consumer, customer, if they're likely in breach? Is it creating greater liability than is required to deal with the risk or the loss that you think you might face as a consequence of their conduct? Third there is, are you trying to limit their right to raise a dispute? Are you trying to crimp their ability to take issue with what you do, where it's legitimate to do so? If that happens, I think you're certainly going to have an unfair contract term. You're trying to put penalties on a consumer or customer if they change their mind or if there's other changes that occur in relation to the contractual relationship, and the outcome of that is clearly disproportionate to the financial loss or damage that you might suffer from that occurring. Again, it's an overreach issue. Do you retain for yourself broad rights to unilaterally vary terms or prices or dates of things happening? If you do, is there any thing given to the customer where they then have the right to say, well, if you're going to change that, I then have the right to review my position and opt out without penalty or renegotiate terms and so forth. If it's one-way traffic, you can count on it being viewed as a starting point as an unfair contract term. And the last two there, which you can deal with yourself in terms of payment terms being fair or not, and specifications. So I might hand over to Simon to take us home.
Thanks. So just stepping back a little bit from the ACL quickly, there is a relatively new, it came into force in January 2021, legislation in New South Wales that basically is imposes a disclosure obligation on any business that is supplying to consumers in New South Wales. And what it does is it requires those businesses or suppliers to take reasonable steps to ensure that consumers are aware of any terms that may substantially prejudice their interests. The idea behind this is along the same lines as the unfair contract terms. It's aimed at increasing transparency so key terms aren't hidden from customers and sort of buried in lengthy documents. Basically, what the reforms are intended to do is address any information asymmetry, as I said, increase transparency, improve consumer awareness, and also to put consumers on notice of recommendations made by intermediaries. This legislation also applies to intermediaries acting on behalf of a supplier. And an example of that may be someone recommending accommodation on behalf of hotels, and the disclosure would be required is that they're receiving some sort of payment for successful bookings or something like that. So it does come with some significant penalties, and we're looking at $110,000 per contravention for corporations. So the disclosure obligation is real. In terms of the types of clauses that would need to be disclosed, they're similar to what Ian was talking about with the unfair contract terms, allowing terms that allow a supplier to share identifiable consumer data, limiting the supplier's liability even when they're at fault, requiring consumers to pay exit fees and referral commissions. Others may be making the consumer liable for damage to goods that are delivered, or automatic rollover clauses, or interestingly permitting a supplier to withhold a deposit or payment in the event of cancellation of COVID, which is I'll get to in a moment. What are reasonable steps? Well, they may require the legislation is directed at making sure that these terms are disclosed. And so what a reasonable step is will depend on the type and the nature of the business. But it may be having a statement up front in the terms and conditions that points out these particular terms, or mandatory statements in call centres, or a pop-up box online on an online website, or text at the top of a web page. But what is important is that it is clear and is clear to consumers what these terms are. It doesn't affect the terms themselves. That's covered by a different regime, but it's about disclosing them. It's clear and upfront. Lastly, I just wanted to talk quickly about how the ACL has fared in COVID, and it relates to a point I said a minute ago. But the ACCC has been fairly busy in responding to issues that have arisen under the ACL and in relation to the Competition Consumer Act more broadly. And that you can see on the right some of the activities that they've engaged in. But more interestingly is the number of complaints that have arisen from the ACL to the ACCC during the period of 2020. And if you look at consumer, it's risen by almost 75% in 2020 since 2019. And drilling down a little bit more, that is particular to some industries more than others, and in particular the travel industry, which has risen by almost 500% over the course of those 2 years. And so that led people to ask questions of whether there is a gap in the ACL, and Choice seems to think that there is, because the ACL contains exemptions for complying with certain obligations, such as the consumer guarantees, where the breach is a result of someone's actions or omission other than the supplier, or caused by something independent of human control. And that's more like a force majeure clause. And an example that this has come up in frequently is where a supplier in the travel industry, and it goes back to the 500% increase in travel complaints, as the supplier takes a booking or a deposit, and then that event is cancelled, and complaints have arisen as to whether the consumer is entitled to get that booking fee or that deposit back. And suppliers are pointing to the fact that because of COVID and because of lockdowns and travel restrictions, they're causes that are independent of human control, and therefore they're not required to comply with those obligations. That in turn has led people to look for other ways to get recourse, and two are up on the slide. For example, the unfair contract terms law, or the law of frustration. Just quickly on the unfair contract terms, that did come up in a case of firm in Kimberley Cruises, where the cruise operator did accept bookings following people agreeing to booking terms and conditions. That was a standard form contract. That contract contained basically a non-refundable force majeure sort of clause, including in the event of a cyclone, and that cyclone did arise. And that cancelled the cruise, and they didn't provide a refund. the insurers on behalf of the tourists brought a claim against the operators that the term was void and therefore unenforceable, and the court found that it was, and the operator was required to refund the money. Interestingly, the clause was determined to be void at the date of booking, and the reason that's interesting is because the tour operator did a number of actions, such as paying for evacuating people on flights, putting them up in accommodation, and they used that to suggest that it was reasonably necessary to keep the bookings and the deposits in order to pay for that. But the court found that that was a discretionary matter, and they're under no obligation under the contract to do those mitigating factors, and even at that cost. And because of that, the clause itself at the date of booking was still considered unfair.
So we're here. We come to the end, and it's been a journey. Thank you for being with us. It's take-home message really is the Australian consumer law is pretty important piece of armoury in the regulator's knapsack. It's a piece of law that's certainly one to know in the commercial sphere as well, because it has an impact on commercial dealings between entities and the ability to freely contract, and it impedes in that ability. It's an area that is constantly changing, and not only has changed recently, and there's case law updates that illustrate the way the law is changing, but there's also proposed changes which we've run through along the way, which are under review. So it's an area to keep a close eye on, keep under constant review, and also ensure that your contractual terms are kept up to date, and that you have an ongoing working knowledge of what's happening in this space.
And if you have any questions, please feel free to shoot them through to anyone in the contact section, which we don't have, but we're happy to answer any questions that you may have. Yeah. So if no questions are up on the board at the moment, we'll hang around and answer any if they come up. But otherwise, thank you for joining us today. We hope it's been informative and you've learned from it. Cheerio. Thank you.